Do you have anything else to add in general about the book, or are there any future projects that you might collaborate on?
I think we're just, my hope is that the book contributes to developing more knowledge about a court that I think is very precious, very valuable, very hardworking, so much for us to learn from. I've written articles on that in the United States journals on how the US can learn from the Indian Supreme Court. So this book, putting things in an accessible manner to non-economists, to non-lawyers, to even lay people, we hope to get more information and knowledge out there, both globally and in India.
Anything to add?
I'll say that the Supreme Court of India, as we mentioned at the outset of this interview, is arguably, I think it's safe to say, is the most important and maybe the most powerful court in the world. India is the largest democracy in the world. The Indian court system is the largest common law court system in the world. And the Supreme Court of India is an institution that for decades has wielded tremendous influence and for a long time has been very popular. And our book, I think it's important for us to emphasize, is raising reasons for considering reforms, reasons for concern, not because of any disagreement with the status or the importance of the Supreme Court of India. Rather, it's taking that status and that importance and saying, here's a court that has a very lofty mission, a mission to create access to justice, to enforce the laws of India. And yet, in some ways, as we examine it, we discover, to use the term that Aparna mentioned earlier, the institution is working at cross purposes with itself. Here's an institution that's seeking to create access to justice and yet is distracting itself from that mission with its focus on special leave petitions where it can't actually change the outcomes of cases. As an example, here's an institution that is concerned about giving preference to the common person, giving preference to the disadvantaged. And yet here we see that the most expensive lawyers are those who have the easiest access to the Supreme Court. And so our goal throughout the book, as we highlight what we see in the data, potential avenues for reform, is to say, here's a court that is popular, that is admired, that is powerful, and yet it's also a court that is working at cross purposes with itself. But with the benefit of this data-driven analysis, there might be paths forward for it not to be working at cross purposes with itself, to address some of those concerns. And that ultimately is our motivation in writing this book.
I won't say much about the courts themselves, but more about legal education, put on my legal education hat, and just say that for me, one of the most interesting and, of course, the most deeply learning experience was the kind of light that data can shine on things that we study through doctrine, that we study through, individual cases. We have some account of, we build accounts of the court based on, individual cases and some impressionistic accounts. And the greater availability of data now, as William's already noted, I think can open up new avenues for legal research on the court, which can feed into law reform, but also can build an account for us to think about, what is this court? What role is it actually performing in the Indian polity, so on and so forth. So the big questions that we are asking about the legal system can be answered in one way through data. And I hope, I was never trained in data science as a lawyer. And that's been a big learning experience. And I hope as we move towards genuinely interdisciplinary research, as a hallmark of Indian legal education, I think these kinds of studies will allow getting in more perspectives from other disciplines into the study of law. And that I think is a very exciting development.